Welcome everybody to Legal Tech Week for April 10th, 2026. This is the show where we talk about the top stories in legal tech and innovation. And we've actually haven't had sort of the whole crew together for a while between Legal Week and Tech Show and travel and other things. We did it. We were we had a couple of ringers last week sit in who were first time panelists on the show. Steve Salkin sat in last week, and Kristen Calvi sat in last week, and appreciate that. But it's nice to see some familiar faces here as well. So I'm glad we're all together. And familiar faces, but I don't know, familiar locations. Stephanie, where are you today?
I am in Denver. I'm working from my friend's beautiful backyard. There's 3 large dogs around me that might jump on me at some point, so we might get a little visit. But yes, Stephanie Wilkins, Director of Content, Legal Tech Hub. Same job, different location.
Looks so sunny and warm or something.
It's nice.
All right, Niki.
Is Niki Black. I'm the Principal Legal Insight Strategist at 8 a.m. The team behind My Case Law, Case Peer, and DocketWise. I write legal tech articles and columns for Above the Law, ABA Journal, and the Daily Record. And I also author our legal industry report over on the 8 a.m. side of things.
The 8 a.m. side. And Joe over on the ATL side.
Yeah, Joe Patrice from Above the Law and Thinking Like a Lawyer, the podcast. I am, finally back. I've not been on the show for a really long time because I've been traveling pretty extensively, but now I'm finally back for a few weeks and excited to get back in the routine.
Well, we're glad to have you back. And Steve.
Hey, everybody. Steve Embry. I write the blog Tech Law Crossroads, and I also write fairly regularly for Above the Law. And I, too, have missed the past couple of weeks due to traveling and family vacation and numerous and sundry things, but I'm glad to be back as well.
All of you missed the last couple of weeks except me, I think.
Yeah.
Well, it weren't even the last couple of weeks. It was last week, and I don't think we did it. I think we had a couple of weeks where we had no shows before that.
Yeah. This was not in the general chat, but for anybody following along, we did in our side chat note that Steve does look like he just escaped from the prison. He's in search of the one-armed man.
It finally happened. That's really why I couldn't make it the past couple of weeks.
All right. So how's everybody been? Anything anybody's jumping to talk about today? Because I'm looking at the list of stories we picked, and I can kind of go anyway. But I actually was thinking, Stephanie, I like the fact that you kind of did a deep dive in not so deep of a topic yet, but one that's becoming a deeper and deeper topic. But you looked at sort of how the courts are looking at privilege and AI.
Yeah, it's a topic I've been, sort of predicting was going to come for a while now. And I know we've talked about one, probably 2 of these cases before, but there's a third case that I wasn't even aware of until I started out writing this. But yeah, we've had 3 U.S. federal court decisions that in some way touch on the applicability of privilege, whether it's attorney-client or work product protection, to GenAI use and GenAI, AI-generated materials. So we're far from, any sort of established standard yet, but it's interesting to watch it play out. We all talked about Hefner. I feel like that's the one everyone talks about first. People took issue with it. It's really the only one so far that has touched on the attorney-client part of it. And I don't think there is actually a basis for attorney-client values anyway. I feel like that issue's going to fall off. But in terms of the work product protection part, it's definitely a closer call. And the 2 subsequent cases, interesting, they involved pro se litigants, which I think brings up really interesting points where those courts found that, potentially it could apply. I mean, one of the courts was prospective. They were dealing more with a protective order than retrospective about actually how discovery had already happened. An interesting thing that is starting to come up in a lot of these opinions, though, is really looking at what tools are used, whether or not it's free tier, whether or not it's a paid tier and has guardrails in it. And it looks like courts are really going to look at that, which raises a really interesting, for me, access to justice point, because, 2 of these cases were pro se litigants, and one of them did not disclose what they used at all and tried to claim that the identity of the tool itself was work product, and that was rejected. You have to say what platforms you're using. But yeah, so if we're requiring people to have, higher paid versions, even if it's, the $20 a month or something, It really is like putting cost barriers into this too, which is not an avenue I was expecting this to take, but is really worth considering. But yeah, it's playing out. I think work product protection has a much stronger claim here, and potentially, obviously, case by case. It depends what we're doing. But it's really interesting. I just learned there was a UK case recently too that I haven't really dived into yet. So it's starting to grow as a field. So what I tried to do in this is pull up the main holdings of each of them, put a little comparison chart of where they differ and where they converge at this point, and to see where it goes from here.
Nice. Hey, Julie.
Fashionably late as always.
I know, just
This
the
is pretty
friendly
early for
Canadian-
Julie.
This is pretty early. I'm actually on time.
That's good. Fair point.
Yeah, like the concern I had in the original when we first talked about the Hefner thing, which so this third case is I find really interesting. I kind of think this third case is right. Yeah, I do think it probably is not work product to name what tool you chose to use. But I do like that in these pro se situations, to the extent that pro se folks are going to be utilizing this technology, it definitely needs to have some sort of a protection, or otherwise you're creating a barrier that is lawyers get to use it because they have enterprise grade investments and real people don't get to. And that seems like that can't be the answer. Like of all the and we'll talk about other issues regarding access to justice throughout the show, I think, but it can't be the answer. And so that's why I think that's important. The one thing I would say about the attorney-client privilege, and I do think it's not an attorney, and so directly, I don't think that should ever apply. But I still do have a hang up that the attorney-client privilege covers work that you do in preparation for meetings with attorneys. Like there are some cases about like you doing handwritten notes of what you want to talk to the attorney about and stuff like that. And I still am a little hung up on whether or not what happened in Hefner should count under that sort of a doctrine. Because isn't that sort of the same, just technologically enhanced, you writing down what you want to talk to your lawyer about, which traditionally we have given some protections to. So I still have a hang up there, but more or less, yes, I think the work product is the avenue that most of this is going to come through.
They seem to have made it very clear, which I fully believe in, is that like pro se litigants should be considered attorneys for the purpose of attorney privilege. Which I mean, if it had come out any other way, I would have started throwing things. But yeah,
I think the issues are really interesting. Jennifer Ellis, I don't know if y'all know who she is. She's blogged over the years, but her blog kicked back in again and she's been blogging more. And she really writes some great analysis on these as well. I think the two of you are covering it really well across the board. I just think the bigger picture is, without getting into the weeds of privilege and work product, and I mean, I know you have to talk about attorney work product and stuff, but I do think that at the end of the day, it's just going to get to the point, and I've said this in past episodes, where it's just a tech that we use, and you can't start separating it from word processing or cloud-based software or Google searches or social media use. Like at the end of the day, and certainly they're all slightly different ways of interacting with the online world, and they all apply differently in different situations. But when it comes to treating this differently, because it's this new tool and because it's, I just feel like that's not going to withstand the test of time. And I think these cases are interesting, but they're like test cases, and you're going to have to wait until like 7 or 8 or 9 cases have come down, and there's going to be a pretty clear trend about how this is being treated. And I think it's just going to go the way that it's akin to like any other online tool, and that you can't be making inquiries or output from these tools subject to discovery unless they would otherwise be subject. Well, I guess I'm walking backwards because
I didn't quite. I was sort of with you, but I didn't.
I'm getting into the weeds of attorney-client privilege and work product. But
Yeah, but that it is kind of different, though. I mean, it's different, certainly different than a Google search, because this is really conversational. It's a Google search. You just do a search and you get a bunch of junk and you go through them, and most of it doesn't. But this is like talking to somebody. So that maybe that makes some difference because of the temptation to engage in a conversation that you wouldn't do on other forms of social media, or you would on social media, but you wouldn't on Google sort of things. That makes it a little bit of a closer question. But it is kind of interesting with the pro se approach. So you might have a litigant who consults ChatGPT, puts all his or her secrets on there about the potential litigation. And if that person was a pro se litigant, might have different protections than if they then went and saw a lawyer and got a lawyer, which just seems kind of weird too. So I don't know. I think you're right. It's going to have to shake out, and I think there's a ways to go with it.
Yeah, I think that's the biggest issue, that final point you had, right? With if the pro se litigant uses it versus if they went to an attorney. That stuff has to match up in the end. And I get what you're saying, Niki, that's why you think like it'll be like tech in the way that, social media and email and cloud-based and all of that kind of stuff. I do think it's the creation of, I'm being careful here because when I say like creation of something new, it's using copyrighted material. We know all of that, but there's a different type of output that's coming out of this compared to all the other things I just said. And so I think and this stuff is moving quickly. So what if I, 5 years from now, I'm sending my AI agent to go talk to another AI agent and to bring that work product to the court. Anyway, I just worry about the tier thing. That's the thing that is different, right? Social media, more or less, we all have access to it. Email, more or less, you've got cloud-based, more or less, right? But we are moving towards a system where really there is going to be a big gap between those who are able to afford the high tier generative AI stuff and those who can't. That to me is the big access to justice issue, because whether you're pro se or you have an attorney, you're going to want to have access to the best technology.
Yeah.
Well, so I wrote this week about something that maybe is a little bit of a bridge between those two worlds of self-represented litigants and talking to an attorney, which is this new thing from Courtroom 5 called the Law Accelerator. It is basically, it's a AI powered, well, it's a combination of things. The core technology is sort of an AI powered platform for self-represented litigants to, there's Steve Salkin coming into the chat because he's got the wrong link. It's welcome, though. Steve, you're welcome. Steve is betwixt in between saying, where am I? Hey, Steve, you're welcome to join us. You still have your panelist link.
Yeah, that's the one that got sent to me yesterday. I didn't realize it till I clicked on it. But hi, everybody.
Hang out. Yeah. So, what I was so I did a story this week on this thing, the Courtroom 5 launch called the Law Accelerator, and it's kind of interesting because Courtroom 5 has been a legal tech startup that's gone through a couple of tech startup accelerators, and they thought, well, maybe this is a good model for self-represented litigants where we can kind of give them some tech tools, give them some training, give them some community support of other people in their situation, and put it all together in a way in which they can be more effective if they're going to be going to court without a lawyer. And so it's a really kind of an interesting platform. And it's really kind of got three components to it. There's like proof is one component where it kind of helps you put together your case and assemble your narrative and even do some legal research, and it can actually kind of automate the legal research to some extent, or you can kind of manually perform legal research within the platform. But then it also helps you sort of put together the strategy around the case and get your filings ready and think about what you need to do in court and how you need to engage with the court and the other parties. And it helps you generate all of the documents. And then, as I say, there's a whole community aspect to it where there's this whole forum where members, everybody, all the users are referred to as members, and they can all kind of talk to each other about, has anybody ever encountered this and how have you handled it? And there's even an office hours thing where they can go in and talk to one of the founders of Courtroom 5 and kind of talk through the process a little bit. All with the great caution that we are not providing legal advice here, but we are just helping you through the process. But I thought it was really interesting because it really does try and put a higher level of structure around getting self-represented litigants to the point of being able to represent themselves without just kind of throwing some forms at them or, telling them this is the court you should be filing in, or these are the documents you need. And it does use AI to some extent. I'm looking forward to Monday. I'm going to be doing moderating a panel at LitCon at Suffolk LitCon on access to justice tech. Sonia Abron from Courtroom 5 is going to be one of the panelists on that, talking about this. So I'm looking forward to seeing how people react to it. But I mean, it's kind of a way of sort of a little bit bridging those worlds between not having a lawyer and having a lawyer. and giving a little bit more structured guidance and access to AI tools.
It just seems to me like I think this is, it's great, but it reveals something that I find kind of quietly depressing, which is it kind of feels like we're sitting around accepting that legal services are going to keep getting inaccessible to people with increasing frequency, and we're going to optimize around that failure. We're going to build things to allow people to represent themselves rather than figure out why the whole industry's broken. And there's no simple solution to that, but and it's good that we're doing something. But that was my takeaway as I was reading it was, it speaks to kind of a sadder, more global concern that as things get more and more expensive and fewer people, like middle class folks can barely hire lawyers at this point. It's not just the indigent anymore. And it feels like we're optimizing the failure, I guess is the phrase I would use, that we're just going to make it so that they can do things on their own rather than get lawyers.
There's the flip side to the I understand your I was trying to figure out a more clever word than depressing, but grim outlook. But I think I've said this before. I think any kind of system that you want to support that relates to access to justice has to include a large subset of people who don't even want lawyers but still want justice. And obviously BC Civil Resolution Tribunal is a very easy example of this, where people get justice every day without lawyers present. So it's not that we don't need lawyers, and it's not that we'll ever stop needing lawyers, but we also have a whole group of people who, for various reasons, would love to be able to solve the problems on their own. They would like some guidance or assistance, but they would like to do the work themselves. And there's lots of research and evidence about this. Even people who can afford lawyers would like another person with them as well who's not a lawyer. So and you know what? If the market responds to this, and for Courtroom 5, who've been around for a long time, if they're able to get a clientele who serves them access to justice, I'm here for it. We have been in this legal tech game for so long. I want more of this kind of stuff, this kind of thinking innovatively, because yes, costs are going up, and I'm not saying I don't want that affordable middle ground. I think that's the issue. That's a bigger issue. We don't have that affordable middle ground legal services, right? Like, it's either really expensive or it's this. There's not a lot of in between. But I do think this is a smart way to think about the technology, especially the community part, especially that you want to talk to someone, that kind of thing. I think that's pretty clever. I'm not saying others haven't tried it before, so hopefully for Courtroom 5 this works out. But yeah, I think we need more of this.
Well, and you can bemoan the fact that there aren't enough lawyers, and that lawyers are priced out for much of the market. But you can also just try and do something about it, and I think that's what they're doing here. I mean, it's just a fact. There aren't enough lawyers to deal with the access to justice crisis, and even if there were, they're not going to charge fees that are low enough for most self-represented litigants to be able to hire them anyway. And this has a sort of an interesting pricing model where it's like based on credits, and as you use kind of different features of the platform, you get charged credits, and it tells you in advance this will cost you 60 credits or whatever. But I asked Sonia, what it would cost to kind of go through a full-fledged case up to trial or so, and it's like $1,500, if you go that far. So it's even that may be too pricey for some people, but certainly especially for that middle tier of people who are making too much for legal services and not enough to be able to afford an actual lawyer, it can really be a viable option, I think.
And that's a big group of people, and it's not only individuals; it's small businesses, startups. They all fall into that mix. Then they just can't. And it particularly when you think about things like family law, where so many people are stuck in difficult situations, and they can't afford to get out of them because they can't afford legal help. So I think stuff like this is pretty valuable.
I think another thing that's going to be really interesting to see how it shakes out is, and it's already happening, I read some articles and data points on this, the courts are already feeling like this surge of pro se filings because of generative AI. And so they're starting to get overwhelmed. And because the regular, cases are also moving through the court system. And as you have more and more AI tools trying to bridge that gap, the courts are going to just start to become increasingly overwhelmed. And it'll be interesting. I feel like the courts are going to have this challenge. And then the law schools are going to have this different challenge of trying to place graduates somewhere where there's no position. So it's almost like from top to bottom, the industry, or from start to finish, I don't know, across the industry, there's all the AI is shaking up all these things in a weird way. And I don't think any of these sort of foundational aspects of the industry and the profession are fully ready to deal with it, especially with the rapid rate of advancement. So I always like to zero out. And I think there's an interesting phenomenon, just as companies like this if they do start to succeed in helping people bring more cases to the courts without lawyers, it's going to be interesting to see what that looks like over time.
So it occurs to me, Steve, that people may not know who you are since I didn't give you a chance to introduce yourself. If you would like to introduce yourself, you were one of our ringers last week, which I appreciated very much, sitting on the panel. And you want to give a quick little intro?
Well, real quick, I don't know if I can stay the whole time. I accidentally hit on the wrong link, but that's okay. I'm Steve Falcon. I'm the editor-in-chief of Law Drill Newsletters, which is a division of ALM. Most notably for our group is the Cybersecurity Law and Strategy newsletter, which used to be Legal Tech News before Legal Tech News took over Legal Tech News. And before that, it was the e-commerce law and strategy and e-discovery. So it's been a bunch of things rolled up all into one. So now it's the overall tech newsletter that we do. And I've been with ALM for a very long time, as most of the panel can attest.
And I can attest that because I hired you into ALM way back when.
Yeah.
That's my one claim to fame. You and Horrigan. I hired you and David Horrigan.
I hop off indiscriminately. It's nothing against anybody. I just have to run. So, but it's glad to join you over the time I can.
Julie, I also didn't give you a chance to introduce yourself, even though we all know who you are. But if you want to quickly.
Those who don't know, I'm Canadian. Anyway, Julie Shopawale. I write about legal tech in Canada, sometimes for other places like the US or the UK, but mostly in Canada right now. Yeah, that's me.
All right. So, Niki, we're talking here about access to justice and making legal help more affordable. And one way that one attempt at that has been Arizona's ABS program. And you have a story this week that relates to that, but from a different state.
It caught my eye. Yeah, it's about a New York ethics opinion that dealt with a pretty specific factual scenario, but it dealt with a New York lawyer wanting to be tangentially involved in, let me get the facts in front of me because they're a little convoluted. It was a New York lawyer who was inquiring about whether he could be involved in Washington's, was it Washington?
It was Arizona.
Sorry, Arizona. Sorry. So he was going to be retiring, and there was a trust that was going to be formed, and there was an ABS in Arizona that would be managed by his son. And essentially, the Arizona firm would work with this inquiring lawyer's existing New York firm and a New Jersey firm as contractor firms. And they'd provide legal and administrative services that receive compensation, including referral fees. The trust would hold ownership interest, but would not participate in legal decision-making, which would remain entirely with the licensed attorneys. And so he wanted to know, I had a couple questions, and this just caught my eye because a New York ethics opinion that dealt with these ABS issues. And so I wrote about it. Whether a lawyer in New York could hold a financial interest in an ABS in a state where the ABS is permitted to practice law, whether the lawyer admitted in New York could manage an ABS located in a state where such structures are permitted, and 3, whether this lawyer could have a contractual relationship with ABS where these structures are permitted, where the lawyer shares fees on account that the ABS receives on account of legal work performed in New York. And so, not surprisingly, the committee's decision was, it depends. The committee said it's perfectly ethical for an attorney to hold a financial interest in the ABS in the state where the lawyer is not licensed, as long as the lawyer is not practicing law through the ABS and is merely a passive investor. And then they said, regarding the question of the lawyer's son's participation in managing it, as long as the legal services provided through the ABS did not have a predominant effect in New York, it was okay. Otherwise, he'd be subject to professional discipline in New York. And then regarding the fee sharing issue, the committee said that because the inquiring attorneys admitted in New York only, and legal work for which he would receive a portion of the fees of Arizona law's fees would be performed in New York, he needed to comply with New York's fee sharing rules. So, it was a little convoluted and very fact specific, But I just, it caught my eye because New York was addressing this issue. I mean, I think that things as these sandboxes and these alternative business structures become increasingly common, uh, you're going to see more and more of these issues arising across jurisdictions. There sometimes can be a little bit thorny. The jurisdictions are all going to have to start figuring out what it looks like when you've got one lawyer licensed in one location and the practice of law happening somewhere else, but the lawyer is somehow tangentially involved. So I just thought it was sort of an interesting ethics opinion to write about. So I did. And that's how we got where we are today.
I think part of what's interesting about it is just the fact that the Arizona program has become this launching ground for national law firms that are ostensibly based in Arizona, but that are engaging in practice all across the country. I think we talked about it in the show I wrote last month, I think it was a couple months ago, about this sort of investigatory series of articles that came out of the Arizona Republic newsletter, which talked about the fact that some of these firms are potentially causing consumers harm in ways that aren't getting reported back to Arizona bar disciplinary authorities because it's happening in other states, and so it's not coming up in the through like traditional bar discipline avenues where you'd be able to understand what was happening and track numbers on it. And so this is kind of a different side to that question of how other states, I guess, should be looking at their lawyers' involvement in that Arizona program.
Well, and for me, it's just another example of capitalism trumping altruism, like the situation you're talking about. Like, right, these sandboxes and these alternative business structures that are being approved the goal is to help bridge access to justice. Then capitalism gets in the middle of it all and people try to work the system to make money, and to the detriment of legal consumers. And I feel like that always happens. And I still think, and this is what the data from the legal industry report showed, because we had a whole section on access to justice. Most of the people that were surveyed agreed with me. You need more funding. That's the true way to solve this. Tech can help and it can certainly bridge the gaps, but allowing other people to practice law, that aren't licensed, or coming up with these other alternative business structures, I don't think is going to solve the problem. That's just going to end up ultimately creating situations that don't help legal consumers. And you need more funding. And I know you can't just pull funding out of a hat, but that's what's truly going to solve the problem.
Yeah, I was just going to say the same thing when these alternative ownership rules were proposed. It was kind of all about access to justice. Although I think most of us could immediately see what could happen, and it wasn't access to justice; it was access to money for other larger firms, and even big four accounting firms, which is exactly what happened. And so, but you're right, Niki. That certainly a lot of the technology that we have today will enable people to do more with less. But even if you can do more with less, you're never going to catch up to the need with the amount of funding that's available. And that's always been the problem. It's the problem with legal aid. It's the problem with public defenders. The money that just is not coming.
But you can structure these programs. They don't have to be so structured in a way that they're so open-ended as to just sort of be like breeding grounds for capitalism. That was the problem they were saying in Utah as well. But Utah has since kind of scaled back or made stricter their regulations about who can qualify to be an ABS and what kinds of programs can qualify to be an ABS. And so they have reduced the number of ABS licenses, but they've also enhanced sort of the focus on access to justice by doing that. Arizona was just always like so open-ended that, yeah, that was what was going to happen. And supposedly, partly in response to that Arizona Republic investigation, Arizona, I don't know where it stands right now, but I know that they are looking at the rules and looking at trying to tighten up the rules to narrow the focus to serving Arizona legal needs rather than national legal needs. So interesting to see what comes out of that.
Yeah, I also think we shouldn't lose in this discussion. The regulator still has the responsibility to regulate. So
You Canadians do not understand how America works.
Maybe in your
look at me trying to bring rule of law into this. I'll stop. But okay, going back to the New York opinion though, what I found super interesting is that this is the most common way that ABS is used. We all know when UK opened the doors that this is exactly the scenarios that came out, right? People wanting to retire and passing on their practices to family members or, junior attorneys who, and they couldn't figure out a way to wind down their practice, so they would do it through an ABS. That to me is the irony of this all. And because I think more than half of the ABSs within the first 5 years of UK, I'm not going to remember all the stats, but and I found the opinion actually quite balanced. I know this, I'm low bar here, guys, but I just was really pleasantly surprised how balanced the opinion was, how they actually really looked at it and said, yep, if you do this and you do that. And I was like, hey, I kind of find no fault in this. This is
We're not used to such a happy note. We had to let that linger.
We don't know what to say.
We're all trying to figure out our PDoom score, and you're finding something to be happy about. All right. Joe,
Okay.
hacking on another happy note. Penalties or hacking? What do you want to talk about? You got 2 stories this week you want to talk about.
Yeah, well, I put 2 stories in there. I don't know, I'll just burn through them real fast, and we'll figure out what we want to talk about. One, Jones Day got hacked, and couldn't happen to a nicer firm. They got hacked, and a bunch of their like 10 clients worth of data got taken away. It was done by a hacking group that is a known threat, who had already said that they were going to go after law firms, because law firms are the soft underbelly of all of this. They specifically targeted the Federal Circuit practice, which is where all the trade secret litigation's happening, which obviously makes these very valuable pieces of information that they probably would not have been able to steal from the companies themselves, but can get because they're involved in litigation. They're asking for a ransom. It's unclear if that got paid or not, or what's going on. But I kind of took it as the FBI had warned about the specific group performing this specific kind of attack like a year ago, in the very early days of this administration, before the FBI made it very clear that they aren't particularly interested in caring about actual crime. And so that's where I kind of came away from it. This was a high priority for quite a while. And it's not just the FBI. We also have like the cyber attack, the whole cyber attack unit has been gutted as part of the cuts this administration has done. And the FBI is, spending most of its time figuring out how to get Kash Patel tickets to the Olympics and stuff like that, and flying them there. What's worrying, I think, is that this was a threat that we knew about, and it's a threat that's only going to get more pronounced going forward, likely, and no one's in a position to really do anything about it from the government side. So you're kind of on your own, law firms, and you need to start recognizing that you aren't going to get the help that you probably depended on in the past. So that was the one story. And the other story was just NPR did a bit generally about AI hallucinations, and in that bit, I was interviewed for it, and I put the print piece up, but in our conversation. But apparently, I didn't know that it was also going to be on the radio too. But apparently, it was, because people started emailing me yesterday about me being on the radio, so you could hear my dulcet tones there.
We get to hear your dulcet tones even without NPR, so we're
Yeah.
where
Yeah. Yeah. So yeah, we were in real news. Yeah, that's a good point from the comments. Like, legal tech made real news because we were on NPR, in the death throes of NPR before the administration cuts that completely too.
it's been cut. A lot
By
of
a court
hacking
order.
on the hacking and the ransom. Do these ransoms? Do they still want their ransoms paid in Bitcoin, or have they moved on to like Trump coin or Dogecoin or one of the other?
Well, it's actually interesting. I had this conversation at Legal Week with a company that does cyber security stuff. And they actually said that the collapse going on in Bitcoin, because all of the people at the top of that particular Ponzi scheme are realizing they can get out, that the collapse going on in Bitcoin is actually a useful thing for cybersecurity, because as Bitcoin collapses, since that is the way in which all these people get paid, it has given them something of a reprieve. Not that all hacking has stopped, obviously, but they kind of are taking it as a bit of a reprieve to like get everybody's ducks in a row, because the hackers are kind of holding off and waiting for a way to get, their coin of the realm, quite literally, to go back up in value.
Although it kind of doesn't really. I mean, if you're able to turn it around quickly enough, it really doesn't matter. I mean, it's not falling that precipitously that if you get paid in Bitcoin today and you are able to cash it out in the next couple of days, then you're not really going to lose much on that. And it might even go up. You never know.
I like what Joe's implying here. Bitcoin is actually helping law firm cybersecurity. That's what I heard. That's what I the market.
That's
It's
one
too
take.
hard for them to find an alternative cryptocurrency. That's really that's the takeaway.
But I mean, it's down what, like 30 or 40 grand from where it was 6 months ago, and that is significant. You know, like that's a hell of a drop.
Yeah, but my biggest worry is the whole because I still remember an article I wrote many years ago about cybersecurity where I did have the privilege of interviewing someone from the FBI about, what they were doing. And they were like, yeah, you guys are big targets. This is a long time ago. So I'm sure we have bigger targets now. But the whole idea that we're on our own, are we ready for the moment? That gets me worried. Like there have been some very high profile cybersecurity attacks on law firms within the last, 3 years? So that to me is really scary. Obviously what's happening in Europe and other places, they still do have those kind of systems in place, but I can see why, the US based AM1, AM50 firms are really like the juicy, tasty
Are the
part.
firms that agreed to Trump's pro bono agreements, are they like extra protected? Do they get like super secret protection that the other
double secret protection? Yeah, I don't know. I haven't heard what they get necessarily. It seems like those firms have been jettisoned by the from the administration's good graces almost as quickly as they caved. Like they don't seem to be getting anything
I am
special. Which
shocked.
yeah,
There's no loyalty there. I am shocked.
no, yeah. Pour one out for Pam Bondi. She gone too soon.
I don't know if we agreed on the meaning of that.
Yeah. I mean, what's gonna happen next is gonna be so much worse.
True.
Yeah. Julie, did you have any stories? Did you have a story you want to talk about?
I was waiting for my article on sovereignty, digital sovereignty to be published, and then it didn't. So I was like, whoops. So I'm just here for vibes, I guess. And then I'll talk about that story when it's published next week.
Okay, you could break the news right here. You could have we could be like your test audience for it.
The article was touching on, speaking of cybersecurity, whether we're going to have this trend of different countries now developing their own technology. In other words, infrastructure is, mostly based on things like Microsoft and, all the tech that we're using. So I mentioned countries like France, Austria, Zimbabwe, different places, but it really was predicated on everyone will remember when the Microsoft France General Counsel gave some testimony in the French Senate, and they were like, so you don't give our data to the US, right? Or anyone else? It's safe here. And he's like, so France was like, oh, okay, we are going to divest from Microsoft for all civil servants by the end of this year. So the article is basically about, will that trend continue, which has huge implications about everything we're talking about, and definitely, of course, for law firms. So anyway, there's a sneak peek right there.
No, I'm interested. I saw that France Microsoft headline and didn't have a time to really read into it, so I'm excited for your piece.
All right, so Niki suggested we should bring back PDoom this week. Go ahead, Steve.
No, that's right.
Go ahead. Only because her PDoom meter is off the charts. Is that fair to say? Or?
Much like everything just keeps getting worse, and the Mythos thing is just terrifying. So, and then all the reports of like AIs escaping sandboxes, and like it's just terrifying.
So I brought up the Mythos thing in our little chat, our side, the prep chat, about how scary it is, because the initial reports were very frightening. The more I dug into like software engineer Twitter and started looking like the real hardcore Silicon Valley people, they made me feel a lot better. And then they made me feel a lot worse. And the way they made me feel a lot better was they started showing that actually given what we got, we then ran old models. Like one of them said they ran like the Mistral small model against these same things that were supposedly miraculous that Mythos cracked. And even these small models were able to do it once you pointed them at it. So it made me feel like this is a significant improvement of a model, but it's not necessarily as shattering as they want to make it sound, which is part of the constant all of these frontier models do. Their marketing technique, as developed by OpenAI a few years ago, is make AI sound like it's going to destroy the world and then say, but my AI is the good one. And then that's your marketing pitch. That said, then I started feeling better about it. And then it's got me thinking, wait a minute, no, I feel absolutely worse. That means that we're already past the Rubicon. If these little models could do all of these things that we're supposedly scared about Mythos being able to do, then we've been screwed for like 8 months and nobody really knew it. And now we all kind of understand how screwed we are. And yeah, that's what made me feel worse on the back end.
Well, the Mythos news was also terrifying initially because at least the first way I saw it, the first bit of news I saw on it was like, Anthropic won't even release this model because they know it's too powerful and scary. And I'm like, what now?
But now remember ChatGPT 5, they did that with too. Altman was like, we're worried about even sending this out to the public. It's so scary. And then it came out and it was a thud would be the sound I would say for 5. But like that.
They were specifically like, this can't get into the end of hackers specifically because it's too powerful for them. And I was like,
right.
Cool.
But
later, OpenAI's like, we have one too. We have one too.
Yeah.
Right. Like, we can't give it to them either.
Exactly. But we already crossed that threshold. I forget the name of the Chinese platform.
DeepSeek.
Yeah.
DeepSeek,
like, don't use it. It's so scary as people flock to it. Like, I agree with Joe. I think the threshold of this specific type of like cybersecurity hacker threat is once Gen AI could code. Once it could code, we were already there, folks. Like it just depended on how fast it could code, what it could create, the fact that you can now program it to create its own programs. Like anyone who's remembers the TV show, what was the TV show on HBO about the robots?
Westworld.
Thank you, Westworld.
Yep,
It's literally Westworld.
That's her husband thing to do right there. That was really
I'm here to just be a reference for any TV information people need.
Sorry, I didn't mean to interrupt. Or you didn't finish your thought.
That's it. That's a great way to finish the plot. Because if you see the show, it doesn't end well.
I think someday there will be books written from a marketing perspective about this weird era, because it is very rare for a product, for all the manufacturers of a product to pitch their product as this product is the worst thing in the world and therefore you should buy only mine. Like that is a weird strategy, and yet it is the strategy that has taken hold in this specific industry. I think that's so wild. Who would think of that? Like Coke going out there going like, soda will kill you, but you need to buy Coke anyway. Like that's not the way any other business works.
Even like with the Mythos thing, it was like, hey, hackers, have I got one for you?
And what's all that's come out of it is because of people responding to that. All we've now learned is that, hey, actually, with a little work, you could do all the things that Mythos is scary about with with models that are publicly available. So now we're extra screwed. I don't know. I also saw somebody somewhere in the report, they were like, it cracked one of these things it cracked in the internals. It was like they spent $20,000 worth of tokens to make it do it. And I was like, somebody made a point, like I think it was the face hugger guy, and somebody was like, pretty sure if you threw $20,000 at the problem, anything could have figured this one out. And I was like, oh, interesting. I hadn't thought of it that way, but yeah. It's an interesting document. It's long. It's like 160 pages or something like that, but it's an interesting document. They're like Mythos program sheet. But yeah, I don't know. I came out of it less worried than I came into it.
I think you meant hugging face because face hugger is
yes. And I mean that's what it's named after, right?
I know.
Like it's named at But yes, that is absolutely what I meant. Although it has the same impact as the other ones.
Totally, I know. That made me laugh.
It's even worse to go down any of these rabbit holes. You have to go on to X to do it, because that's where all the programmers are talking about this stuff.
Yeah, that is.
It just made me want to go back to Chicago and hang out on the Comic-Con side of things. Like that just felt like a happy place,
Same. We've got to figure out how to always have Comic-Con and ABA Tech Show in the same weekend. Maybe not the same space. But at least the same weekend.
But not also with legally.
Yes.
We just require cosplay as a condition of attending
Yeah.
tech show.
It was the music too. That music was, I think
Yeah.
I decided we need to have, when like you walk into tech show and they have that little covered thing, they need to have music that plays to set the tone. So like some kind of like club music, right? Like, so you're walking in, you feel like it's going to be really exciting. I'm going to make this happen somehow. I'll bring my own speaker.
We did talk about for Tech Show, for Startup Alley this year, of having each startup get to choose their walk-on music, and that would play between the segments. But the powers that be at the ABA decided that was going to take too much time to play a few seconds of music in between each transition. So we didn't do that, but maybe next year.
And tech show's
Probably
real
had-
early next year, right?
Absolutely. Overlaps with legally.
Oh yeah. What I'm saying is I just looked up the Comic-Con dates and then I was like, oh wait, they're not going to match up because it's.
Yeah, but why does it overlap with Legal Week? What happened there? You're right. Journalists with her dumb questions.
Steve is our official ABA Tech Show representative.
It certainly was not, I'm sure not by design on either show's part,
Right.
but you schedule those shows in advance in part depending upon the venue and when they have the space and what they're charging. And so, yeah, trying to match it all up would be difficult, but it's going to be a challenge.
You could, as we have pointed out, you could pretty much go through the entire year and hit a legal tech conference every week, if a couple of different ones every week. So it's getting to that.
Yeah,
maybe
got
some time off for Christmas and Thanksgiving or something, but that's about it. All right. Well, I guess we don't really need the PDOOM to do the PDOOM numbers because we just kind of summed up the state of affairs.
Does Steve have a story? Did we forget that?
Well, I had one, but they all talked about it last week.
Yeah.
But if you want to hang out after everybody's gone, Stephanie, I can talk about it.
Yeah,
Maybe take it back to
it was the
prison.
story about the survey of judges' use of AI, which we did talk about last week.
Okay,
And
sorry.
actually, it could have been fun to talk about that more because I also did an interview this week on my podcast with Shlomo Klapper, who has this learned hand platform to encourage judges to use AI, and they're gaining some traction around that. So we can revisit that topic. Meanwhile, I hope everybody has a good week. Thanks to everybody for joining us today, and
Yeah. And watch the Artemis splashdown if you don't have other plans.
That's a happy note.
I
What?
hope. Very Gen X trauma, apparently. I learned this when watching the Artemis launch. I was like, oh my God, I'm so nervous. Like, yeah. No, so yeah, Artemis is splashing down just after 8 p.m. Eastern time. Netflix and NASA start their live coverage at 6:30 Eastern time. I'm not actually in Eastern for once, so I'm doing other math. Yeah.
where is it splashing down?
At like San Diego, like off Southern California.
All right.
Hopefully
I'm not
not
gonna see it
in
off the
San Diego.
coast where I live.
Hopefully the water.
No.
I heard the return is going to be the more challenging, the return to Earth.
Yeah.
Well, I read that here.
But the photos have been amazing, and it's just been
Yeah.
so. I'm a giant space nerd, so it's been totally awesome to watch. I'm excited.
Yes, I was watching the coverage and somebody's caption was space journalist, and I was like, I think I picked the wrong.
Oh, I know, right?
I did. Yeah.
Well, that's also like now when I see that there's actually like space law that people do, I'm like, where was that when I was coming up? Why wasn't that being offered to me?
It's a thing. There used to be a ALM journalist named Jessie London. I don't know where she's around somewhere. But she used to write about space law all the time, and she had a blog on space law. And
Missed that. Could have been my true.
Jessie these days. I don't know what happened to Jessie. Yeah, space law is a thing. All right. Well, we will have to blast off down that road next week because we're out of time for today. See you all then.